Well, good morning. This is Ian R. Crane, and I think we have a little bit of a problem with the lighting on the Facebook broadcast, but on the basis that Facebook have a tendency to block my broadcasts, that may not be a big issue. On the other hand, if you want to see this in a slightly better light, then do switch over to my YouTube channel. That's the Ian R. Crane YouTube channel, and hopefully there I think the lighting will be a little bit better. Anyway, um today it is Thursday, the 12th of July 2018, and over the past 2 days I have been at the Manchester civil courts challenging the quadrilla injunction. And of course the temporary injunction was awarded on the 1st of June, primarily against the perceived imminent threat. Let's see if we can get some better lighting here. No, I don't think so. The perceived imminent threat from Reclaim the Power, who had broadcast all over Facebook and social media their intention to have some fun and games at the Preston New Road well site. And on the back of that, coupled with the historic record of direct action at Preston New Road, Quadrilla sought an injunction. Well, it was always going to be difficult to challenge the injunction on the 1st of June because there was clear and present evidence of the Reclaim the Power imminent threat. And the judge decreed that the first injunction should last no more than 40 days. And the power threat would have anticipated, and then he could make a ruling based on a more generic observation about the situation at Preston New Road. So, in the interim period, I was able to work with a small team of people, and primarily that was Ben and Sharon Dean, very ably supported by Joe Boyd. That was, without his help, we would certainly not have been able to prepare the massive evidence that we pulled together here to use during the course of the case. Now, obviously, the primary objective was to get the quadrilla injunction dismissed, but that was always going to be an uphill battle. It was always a possibility. Certainly, it was an uphill battle, particularly without proper legal representation. And here I have to really acknowledge the tremendous contribution of Bob Dennett over the last 2 days, because literally up until last Friday, Bob was under the impression that he would have legal representation in court. And in fact, a firm of solicitors who will remain nameless for the moment, but had certainly alluded to the basis that he would be represented in court, and he didn't need to worry because he would be there. But fortunately, he'd done a lot of groundwork, and on Friday afternoon, when basically they dropped him right in the smelly stuff, Bob stepped up to the plate, and he was determined that the evidence that he had accumulated, particularly challenging the witness statement of James Dobson, would be effectively challenged in the court. And he did an outstanding job under very circumstances. It's all things, it takes practice. But Bob, and he was very ably supported by his Mackenzie friend Richard Marshall, and Morgan Marshall was also present for both days. So this really shows the commitment and conviction of at least one of the Lancashire residents. But so although my game plan was that I would be operating as litigant in person, but obviously the expectation was that I would be doing that in a sort of unison with the legal representatives of Bob Dennett. Anyway, as it happens, what we did was we pulled together a massive bunch of information, effectively challenging the legitimacy of not just Quadrilla, but history on the basis of the imminent threat that it presents to the ecology, to the environment, and to the health and well-being of the people who live in the sacrifice zones. Well, I also knew that the judge was basically going to be somewhat hamstrung. And one of the reasons that I decided that I had to function as a litigant in person was because I knew that I was intending to submit evidence to the court that if anyone with a legal background tried to submit, the judge would immediately slap them down because they should know better. So the reason we put nearly some 2,000 pages of evidence together, including the compendium put together Sandra Steingraber, professionals in New York, and the MEDAC report, along with a whole bunch of other information, was to make sure that the judiciary and the industry knew what evidence was in the public domain to challenge this at some future date, because we knew it couldn't be challenged now. And the reason that we knew it couldn't be challenged now is because of a ruling that was made in a case in London back in 2012. In fact, I'm going to switch off the Facebook transmission. So anybody watching on Facebook, please come across to YouTube. And that ruling in 2012 was in a case of City of London versus Samid, and it followed the efforts by the City of London to remove the protest camp from the city centre in the steps. I'll read you a paragraph from the summary of the judge's ruling there, and you'll understand the magnitude of the problem that we face. And I'm going to explain, this will help to explain to you why it is that this country is in the grip of a corporatist dictatorship. And we maintain the charade of a democracy, but what is now definitively proven is that the corporations have absolute supremacy over the private citizen. And of course, had TTIP manifested, or should it ever manifest, then the situation will get far worse. So this ruling by the judge in 2012, no one has doubted, or could, the significance of the causes the defendants promote, or the sincerity and passion with which they are doing this. Views will divide on the thoughts expressed. Some might gain a wide consensus, others might not. However, this is not for the court to decide, or not for the judge, nor for the court. It is not for the judge nor for the court to venture views of its own on the substance of the protest itself, or to gauge how effective it has been in bringing the protesters' views to the fore. The convention, the European Human Rights Convention, rights in play are neither strengthened nor weakened by a subjective response to the aims of the protest itself, or by the level of support it seems to command. Mr. Forsdyke submitted, and I agree, that the court cannot, indeed must not, attempt to adjudicate on the merits of the protest. And then a very interesting statement: to do that would go against the very spirit of Articles 10 and 11 of the Convention. Here's the situation. Quadrilla, or any other of the unconventional gas companies, can come along to a civil commercial court and present the evidence of imminent threat to their ability to operate to the full extent of their license due to the threat of protest. And yesterday, Judge Pelling set a very, very low bar, because basically, whilst the Reclaim the Power threat was, a real and clear and present risk, what was put forward over the last 2 days was simply an observation that there is a global crackdown protest scheduled for October 17th, which has no direct bearing on Preston New Road whatsoever, and a video that had been posted calling for direct action. And that was it. All the rest is pure conjecture. So the fact that we had submitted this evidence to the court for consideration, the judge, whether he wanted to or not, and I'm not going to offer any conjecture on that, but whether he wanted to or not, was hamstrung. Now, obviously, CUADRILLA and the other companies do not want this information presented in the courts. And so much so that after I'd submitted the evidence bundle to CUADRILLA's legal representatives, I got a letter from their solicitor basically telling me that they were going to move to have the evidence dismissed as irrelevant. So listen carefully to this. So the evidence of harm, the evidence act, the evidence of the ecological damage that this industry has caused wherever it has established a presence, as far as the courts are concerned and the legal profession is concerned, is irrelevant thanks to that ruling by the City of London versus Samid case. So here's what they wrote. Your evidence fails to have regard to the fact that the judge decided at the last hearing that arguments as to the merits or demerits of fracking are irrelevant to these proceedings. Much of the evidence is also in the nature of purported expert evidence, well, of course, for which you do not have permission. We will be arguing at the next hearing that the evidence should be disregarded for these reasons. Well, I thought, okay, I'm going to have to do something about this. So I wrote to the judge and basically said that CUADRILLA's solicitors were somewhat jumping in the, seeing as they hadn't seen my skeleton argument. And I was absolutely cognizant of the fact that the judge had said that thanks to the City of London ruling, that the merits and demerits of fracking could not be taken into consideration. But I let it be known that I would invoke Article 6 of the Human Rights Convention, which is the right to a fair hearing. And how can a hearing be fair when the application for the injunction is simply based on social media and conjecture versus the established scientific and academic and experiential evidence from the unconventional gas fields in the US and Australia? So, to be fair to the judge, he did give me the opportunity to introduce some of the scientific and academic evidence and the experiential evidence, particularly that of Helen Bender, which I'll refer to again in a second. But after half an hour, he smiled and said, "Now, Mr. Crane, I think you will appreciate that I have been patient." And, I knew that basically at some point he was going to just say, you know what, basically you can talk about this stuff until you're blue in the face, but in the legal environment right now, it can have no bearing on the decision making of the court. So here is the prima facie evidence that the corporations are effectively usurping parliamentary law. And I mean, this was a statement that I made during the hearing, which the judge acknowledged in his ruling, in his summation. Parliamentary law, and obviously the police do what they do to manage police balanced protest. And they have a range of laws in which they can, use. It's, like obstruction of the highway. They've tried to use the trade union labor relations legislation. There's public nuisance. And then, of course, it goes before the Crown Prosecution Service, and the Crown Prosecution Service decide whether or not there's enough grounds for a prosecution. And then it goes before the magistrates or the district judge, who then decide whether or not an offence has been committed. But that isn't enough for the corporations. And so basically, the application for injunctive relief is a statement that the companies are just not happy with the policing and they don't believe that the law goes far enough. And so they just go along to the civil courts and get an injunction where the penalty in the event of Quadrilla proving in a court that they have been caused loss or harm as a result of protester action, then they can apply to the civil courts for a contempt of court ruling and apply for compensation. Now, that compensation can be in the form of taking somebody's assets from them, or a proportion of their assets, or demanding a custodial sentence. So effectively, they're saying we are establishing a raft of legislation which goes above that of parliamentary law. And so, there it is. That's a fact of life. So my great thanks to the people who did put the time and effort into producing witness statements. That was ranging from Vera Scroggins and Sandra Steingraber in the United States, to Helen Bender. And of course, Helen's father sadly committed suicide 2.5 years ago as a direct result of the pressures put upon him and his business, his agricultural business, by the unconventional gas industry. And in fact, the Quadrilla legal team tried to seduce the judge into not reading these witness statements, and they literally tried to dismiss Helen Bender's statement as that of somebody who has an experience of living in proximity of the unconventional gas industry. No mention of the fact that the statement went into considerable detail about the negative experiences, and of course about the fact that her father had sadly succumbed to the pressure and felt that there was no other way other than to take his own life. This bundle of evidence is now prepared. Obviously, it can be added to, it can be modified in whatever way, shape, or form, but we have to find a way to get this evidence into the courts. And the only way in which this is likely to happen in the foreseeable future is the success, hopefully, of the challenge to the INEOS injunction being brought about by Joe Boyd and Joe Corey. Because until such time as the Court of Appeal changes the 2012 City of London versus Samid ruling, or the Supreme Court change it, then this is what hamstrings the judges today. Like I say, whether or not they want to take account of that evidence is an irrelevance because they can't. So sadly, that's the situation that we are in. So obviously the anti-fracking community has to be agile. It has to be creative. And most importantly, of course, it has to take the issue to source, which is the government. And primarily right now, of course, that's Greg Clark at the Department for Business, Energy and Industrial Strategy, and James Brockenshire, the Communities Minister. And basically, it has to be understood by central government that the communities will not roll over, and they're certainly not going to be bullied by the corporations or the civil courts into accepting an industry into their community, which they know, because of the evidence and the experiences of people from anywhere in the world where the industry is print, then they have to challenge it in whatever way they can. So the industry is never going to get a free ride. Now, Quadrilla, by their own admission, recognize that these, even if they get permission to do the test fracks, which of course one certainly hopes that they don't, especially on the basis that they got no evacuation plan in place. There's no emergency response plan in the public domain. So there's a whole host of reasons why neither Greg Clark or James Brockenshire should sign off on it. We understand that the Environment Agency has signed off on it, but they were probably told that if you don't sign off on it, then we're going to cut your funding. So the importance is to keep the pressure on central government. So this is obviously never going to be easy, and what we don't want is a temporary situation. Ultimately, it is imperative, because the entire north of England is effectively under threat. I mean, I happen to be in an area in the High Pennines that's just outside the pedal areas to the west of the Pennines, and then there's a bit of respite until you get over towards Leeds and Bradford. But nonetheless, some 80% of this part of the country is under threat from the unconventional gas industry, and it has to be challenged, and we have to keep chipping away. And on Tuesday, when I was presenting some of this evidence to the court, I'm told that I was obviously speaking to the judge, but I'm told that the CUADRILLA legal team were extremely uncomfortable, and so they should be. And of course, this is why they are doing everything they possibly can to make sure that this evidence isn't admitted in court. But it is imperative that we invoke Article 6 in any courtroom situation and demand the right to a fair hearing. Of course, we're not going to get it because of the City of London versus Samid ruling. So, we're in this sort of cycle right now where, it's a no-win situation, except that this type of ruling, and the fact that INEOS have sought this ruling, UCOG have sought this ruling, and now CUADRILLA have got this ruling, people can now see for themselves that the corporations are not interested in the health, the well-being, the environment, or the ecology. Their sole motivation is greed, and more greed. And if you have concerns about that approach and that attitude, then it is imperative that you find a way to get involved in this. And of course, there are also other campaigns as well. And I should also mention, of course, the Sheffield Tree campaign, where injunction has been sought against the protesters there. And of course, this is done on the basis, again, of it is a corporate contract between Sheffield County Council and Amy. And so they are seeking the injunction on the basis of the corporations. And once again, of course, the courts cannot take into account the evidence. And of course, the evidence that would have been put up until a few months ago was simply on the basis of, well, we need the trees down to be able to repair the roads. But with increasing evidence that basically the trees are having to come down G telecom system, and a few days I posted a video on my Facebook page from Bournemouth, where the people in Bournemouth who are preparing for the 5G rollout in Bournemouth actually state in the video that it's not just trees and foliage that are a problem, even hanging baskets are a problem. So, it's really important that people start to realize that the democracy is a charade just to keep you placated. Ultimately, this is a corporatist, totalitarian state where the corporations can basically do what the hell they want, regardless of the damage and the negative impact that it has on you, your family, the local economy, the ecology. There's much more that I could say on this, but my tremendous thanks to Ben Dean and Sharon Dean, Joe Boyd, Bob Dennett, Richard Marshall, Morgan Marshall, Helen Chunso, and the people that contributed to my evidence: Keith Taylor, MEP in the southeast of England, Sandra Steingraber, Vera Scroggins, Helen Bender, Sir Richard Story in North Yorkshire, the Mayor of Malton, Paul Andrews, Adela Pickles, writing on behalf of Frack Free Rydale. Your contributions to this bundle of evidence were truly outstanding, and hopefully in any future attempt by the unconventional gas industry to get an injunction, we have to find ways to introduce this information into the court hearing. Even though the judge is hamstrung, it has to be aired, and we do that under Article 6 of the Human Rights Convention, the right to a fair hearing. So anyway, I was going to enjoy a day off today, but it's actually misty, and believe it or not, it's raining for the first time in about 6 weeks. So I've got another little project that I'm going to help someone out with today. But I will be back tomorrow morning, hopefully outside. And then normal service, hopefully, will be resumed with the morning live streams next week. So thanks for joining me. Please do read Ruth Hayhurst's article that she's written from yesterday's hearing, and I spent some time speaking with Ruth, as did Bob Dennett and Ben Dean after the hearing, encapsulated the situation. So if you don't want to spend 25 minutes or whatever listening, then do read Ruth's article. Meanwhile, I have one of my very unusual public speaking events scheduled for next Wednesday in Marlborough, which is situated almost equidistant between Sheffield and Chesterfield and Worsop. I think it's just about in Derbyshire. But anyway, that's at Marlborough. That's next Wednesday evening, and I will be sharing more details of that on social media, and obviously I'll mention it on next week's live stream. So meanwhile, sorry we couldn't do more in the courts in Manchester over the last 2 days. But I think those few people who came along to support us will have had a bit of an education, and hopefully even come along or weren't able to come along to support will now understand or have a better understanding of the magnitude of the opposition that we face in getting this pernicious industry shut down in this country. And a final word of thanks to those people who contributed to the crowdfunding that we set up to underpin this challenge, because the printing and stationery costs alone were not insignificant. And I can tell you that we had significant expenditure, and which would have fallen on us as individuals. So thank you so much for easing that burden and giving us the support. And I will catch with you tomorrow. You take care now.